Hello and welcome to another TLDR EU video. When it comes to laws and the judiciary, things get pretty complicated pretty quickly. Add in a supranational dimension such as the European Union, and those complications, well, they develop their own further complications. One of the more prominent and ongoing legal battles concerning the EU relates to Germany and their constitutional court. In any case, it seems that the European Commission has had enough with Germany, with it being reported that the Commission will take legal action against the country. So in this video, we'll explain just what on earth is going on, what has led up to this point, and what this all means for the EU's legal supremacy. Before we start, just a quick reminder that if you want to support the channel, you can pick up one of our Countries with Shoes pin badges. We have these high quality enamel pin badges for every EU country and the EU itself, as well as a bunch of others. And if you buy any 3 pins right now and use the code Macron at checkout, then I'll manually add a random signed badge to your order. The link to the store is in the description, and we really appreciate your support. To get to the heart of the current issue, we have to rewind to the height of the Eurozone sovereign debt crisis in 2015. To put things as simply as possible, one of the biggest issues during the crisis was the fact that despite interest rates were really low for the average Joe on the street, for countries such as Greece and Portugal, lenders wanted greater than normal return on their risky investment. And as the crisis began to develop further and further, that greater return increased more and more. Basically meaning that these countries were paying astronomical rates on their debts, rates that were ultimately unsustainable. So the European Central Bank decided to step in, undertaking some less than conventional practices, including notably quantitative easing, with the programme at the heart of this debate being the Public Sector Purchase Programme. Under PSPP, the European Central Bank bought up bonds issued by governments, government agencies, as well as European institutions within the euro area. The economic theory being, again, this is a vast oversimplification, that by buying up bonds you increase demand. By increasing demand you raise the price. And given the yield, i.e. interest payable on the bond, is inversely related to its price, then as the price goes up, the interest goes down. Meaning that it ought to have become cheaper for Eurozone governments to borrow, at least in theory. Anyway, the macroeconomic technicalities aren't what matters here. The legality of the programme is. At the same time as the PSPP programme was announced, the Federal Constitutional Court of Germany had actually asked the Court of Justice of the European Union to assess the legality of a separate but otherwise incredibly similar ECB programme on 2 grounds. Firstly, they wanted to determine whether the programme fell within the ECB's mandate, and secondly, whether it amounted to monetary financing, something that was prohibited under the Treaty of Rome. The Advocate General then published an opinion upon Germany's request, stating that the programme was both within the ECB's mandate and complied with European treaties. As the European Parliament's own report on the matter highlights, the opinion was interpreted by a number of commentators as giving the green light to quantitative easing in the euro area. However, things didn't settle down following this ruling. That's because the Court of Justice of the European Union also took on a similar case, this time directly considering the legality of the PSPP programme. The CJEU considered the case in full and came to a conclusion that the programme, although unconventional, fell within the EU's remit, remarking that quantitative easing is an accepted form of monetary policy and thus falls within the exclusive competence of the ECB with respect to Eurozone countries. So far, so good, right? Well, in May 2020, Germany's Constitutional Court, in spite of the CJEU ruling, issued its own final ruling on the PSPP programme. Many spectators expected that the court would side with the CJEU judgment, but they didn't, and in a somewhat weird turn of events, the German court ruled that the CJEU judgment was in itself ultra vires, essentially arguing that the court didn't have the authority to ever rule on the case. The German ruling highlighted that the ECB's bond purchases were obviously not covered by the ECB's mandate, and ran the risk of being illegal under German law unless the ECB was able to prove that the purchases were indeed justified. Failure to provide sufficient justification within 3 months would see Germany's national bank barred from participating in European bond buying schemes. This immediately set off alarm bells. As the ECB's largest member, it would have been all but impossible for the ECB to continue bond buying without German support. The European Union, however, remained disturbed by the fact that Germany had seemingly overridden the principle of the primacy of EU law, the principle that EU laws supersede national laws in many areas. So on Wednesday, in an attempt to right this, the European Commission formally began legal proceedings against Germany. In an explanatory note accompanying the news of the infringement procedure, the Commission highlighted how the Constitutional Court's ruling set a dangerous precedent for Union law. A Commission spokesman added to the explanatory note, affirming that the German court's decision was a direct violation of the fundamental principles of EU law, going on to claim that this could threaten the integrity of Union law, stating that the last word on Union law is always spoken in Luxembourg. As Sven Giegold, a German MEP, highlighted, depending on how this infringement procedure goes and whether Germany backs down, could have truly immense ramifications on the European project as a whole, with him stating that Germany's ruling was a dangerous gift to right-wing populist governments. If a supposedly bad justification by the ECB is considered an ultra vires case, then Hungary and Poland get a powerful instrument against EU law. In essence, at a time where both Hungary and Poland are being admonished by the EU for democratic backsliding and ignoring the rule of law, it's not great for one of, if not the most influential member state, undermining the Court of Justice's primacy when it comes to all things European. The EU's concern is that if Germany wins here, then what stops other constitutional courts in other countries from picking apart EU laws and undermining the principle that the EU ultimately stands above national debate and policies? The German government now has 2 months to respond to the letter of formal notice. Depending on this response, the Commission could go on to send Germany a reasoned opinion, a formal request to comply. If Germany doesn't comply after that, the case could potentially get referred up to the Court of Justice, the very same court this entire debacle surrounds, who have the power to levy hefty fines, on both a lump sum and on a daily payment basis. And under current calculation procedures, the minimum lump sum fine for Germany would stand at just shy of 11 million euros. But what do you think? Who should have the final say? The Court of Justice for the European Union, or the national courts such as Germany's Constitutional Court? Who do you think is in the right here? And ultimately, are we about to see national courts beginning to pick apart European law, and with it, the very fabric of the EU itself? As always, let us know your thoughts in the comments below. Be sure to subscribe to the channel and hit the bell icon to be notified every time we release a new video. Special thanks to our Patreon backers who make videos like this one possible. And if you want to see your name at the end of videos, then you too can back us on Patreon. The link to that is in the description.